Hello, everyone, and thank you for joining us here today for our annual PTAB conversation. We have in store over the next about 28 hours, 9 different panels, lots of networking, a couple cocktail receptions that we hope you'll join us for. And we look forward to talking about the issues that are going on at the PTAB today. We'll talk about legislation. We'll talk about some of the problems, maybe staying out of trouble with our ethics panel. We'll have a judges panel. And we'll talk about rolling up our sleeves and actually doing the work at the PTAB, best practices across the number of our panels. So thank you for joining us here today. I'd like to always remind everybody before we get started here, there's the people in the room that you're speaking to, and then there'll be a much, much, much larger audience that will watch this later on. So several of our panels will be off the record. The judges panel will be off the record. The in-house panel will be off the record. But most of the panels are for the record, so we'd like to have you all participate in the conversation, but just realize that we are recording. We have a microphone here if people would like to chat as well. So what I'd like to do here now, if we can, is introduce our first panel. And the first panel we have here today, and I'll start from the audience's left to right. We have Jim Carmichael. Jim is founding partner at Carmichael IP. He is a former APJ. He is also either individually or the firm collectively on any given year in the top 1, 2, or 3 in terms of patent owner win success rate. Jim is a friend of mine. Glad to have you here. Thank you, Jim. And thank you again for co-chairing this program.
Thank you, Gene. We appreciate you holding it.
And then next we have Director Yanku, Andre Yanku, former director of the Patent and Trademark Office, current partner with Sullivan & Cromwell, and one of the folks who is going around town constantly trying to save the patent system and work towards a more rational, fair patent system for everyone. Andre, thank you for being here.
Thank you.
And then next to Andre, last but certainly not least, is Scott McEwen. Scott is also co-chair of this program. He is a shareholder at Wolf Greenfield. He is also a longtime friend of mine. I'm always glad to have you here as well, Scott. Thank you for agreeing to chair this again. Oh, and he is the author of, really, if you don't read it, probably everybody does read it, but Patents Post Grant is the way that you stay up in the world with everything that's going on in the PTAB. And Scott, with that introduction, maybe I'll start with you first to get your preliminary thoughts on the conversation that we're going to have here today.
Well, it's first, thanks for having me. Over the past couple years, I used to do sort of a top 5 developments at the PTAB on my blog every year, and last year I sort of got away from it because we're sort of reaching what I consider to be more of a steady state, with respect to PTAB practice. That's not to say that there aren't a lot of things to talk about or people still aren't concerned with some of the things that are going on there. But, over the past 10 plus years, I think we've sort of sorted out some of the more fundamental issues in terms of the Administrative Procedure Act and how that all fits with the trial practices and some of the various discretionary approaches that the office has taken over the years and what 325D means. So we've now gotten to the point where, certainly there are some issues that are going on with, sanctions. This year was a big issue, but from my perspective, hopefully I don't have clients that are too concerned about being sanctioned. I'm not worried about being sanctioned. So, didn't pay too much attention to some of those things. So we've gotten to, I think, more of a, like I said, a steady state situation where, we're seeing sort of changes in policies as the directors come in, and we saw that with Kathi coming in and doing some things with 314A that were different from what happened previously. And so it's more of, I would say, political changes that I'm watching more these days than sort of these systemic, big picture issues that, sort of characterize the first 10 years or so.
Great, thanks a lot, Scott. Andre, I'd like to get your preliminary thoughts here before we dive into the conversation.
Yes, thank you. So I generally agree with what Scott said, and since we're all going on record to say this as one of the major accomplishments is that I also have not been sanctioned. So I generally agree. The PTAB seems to have reached what I would view as, by and large, steady state. To a point where we sort of generally know how things are going. There haven't been major changes recently, and frankly, to some extent, we seem to have settled on a set of issues that are either good or problematic, and and they are at steady state. So, for example, the concept that we continue to have parallel proceedings in the district court and at the PTAB, we seem to be in a pattern now. We sort of know what to expect. I don't think that's a good thing. I'm just saying that that seems to have settled in. And Scott is right. I think the major kinks have generally been worked out, but it's not necessarily that they have been worked out in a good way. Some in a good way, some not in such a good way. There's definitely a lot of room for improvement, and hopefully during the course of the panel we can talk about all those issues.
Great. Thanks a lot, Andre. Jim, last but not least, let's get your preliminary thoughts here.
So although the major issues have been at a steady state since we last did this a year ago, I don't think that's necessarily a good thing. There's three things that really bug me that are going on right now that aren't getting enough attention. One is panel dependency. There's over 200 APJs, and if you look at a bell curve of what the results are, some of them have never ruled for patent owner. Some of them have never ruled for petitioner. And there's too many at the extremes. I think something needs to be done about that. Of course, they have that at the Federal Circuit too, but there are Article 3 judges, you can't do anything about it. Article 2 judges, they're employees, and you can do something about that. So that's my issue number one. Issue number two is for patent owners. Unfortunately, in IPRs, we constantly face, once we put in a patent owner preliminary response that seems to kill the petition, the petitioner is almost always granted supplemental briefing, preliminary supplemental briefing about practically anything they want to. I believe that runs against the Supreme Court decision in SAS that is supposed to have the petition define the boundaries of the challenge. And then finally, gang tackling. You might think it's been taken care of. Certainly victory has been declared, but I don't think it's been won. Particular with member-based organizations. We had a case, you're probably familiar with applications in internet time versus Salesforce, where we showed that RPX was a real party in interest with Salesforce, and therefore they couldn't both be gang tackling and pretending that they were doing things differently. So we did get one of those quashed. But then as soon as that happened, I noticed unified advertising. Hey, after the RPX AIT case, we're now the only ones that can do this. So we still have that going on. And those are three preliminary thoughts, and I'll have some more questions for these guys.
Okay, great. So as we transition into the conversation that we want to have, the topic of the day, if you haven't picked up on it yet just now for this panel, is PTAB Insights, examining the PTAB landscape. And this is as it exists today, and maybe as it has also existed over, say, the last year or so since the last time we were here together to do this. So I guess the question that I have is, and I know we all collectively talked about trying to come up with some ideas that we would like to say that will make the PTAB better, which we'll talk about that here in a minute coming up. But if you had to put your finger on like a big issue or big development, whether it be a case, whether it be maybe it could even be a big nothing burger, perhaps with the rules or the legislation or some kind of policy or politics, or what would you point to for people to say if you weren't paying attention over the last year, you really should consider this? Scott, why don't we start with you here first on this?
Yeah, there's a couple, and I guess the one that, and I wrote about this back in September, that I think is just a black eye for the agency, is the current oral hearing practices. And believe it or not, this is me being pro-patent owner. The current policy is, unless both parties agree to a live in-person hearing, then there won't be one. So, for example, if you're a patent owner and you file your oral hearing request and you say, I want a live in-person hearing, and the petitioner comes along and says, well, we think virtual is fine, then, effectively the petitioner can prevent the patent owner from, being in the same room as the judges. And, while from a practitioner perspective, I don't think that's going to change, that's just my view and the number of cases I've done. I don't think it changes the outcome, but the perception, I think, is the problem. And if I were the director and being called up to the Hill and someone asked me, is it true that petitioners can effectively keep the patent owner from even being in the same room as the judges? I wouldn't want to be in that seat and have to answer that question. So I think it's just dumb, frankly, to allow something like that to be a practice. And, particularly over the years, there are a lot of people that are unhappy with the PTAB and have labeled it, in various ways that it's anti-patent owner. So to have a policy like that is just dumb.
Yeah, I agree with that. I think that when you look at a lot of the stuff that goes on at the PTAB, it's hard to understand why do you have to cling to that? Because it doesn't seem like it would make too much of a difference. We talked many years ago when we were trying to talk about making the claim construction standard the same. You said that you didn't think it was going to change anything, and that question just popped in my head now when you were saying that you don't know that it would change anything having them actually in the room, but it just doesn't feel right. And two things: has it changed anything in the claim construction standard in your view? And two, has at least maybe the perception been beneficial because now it's like one set of rules across?
Well, and that's what, in my view anyway, was what the change was all about as well. There's a standard in the courts. Why don't we use it here? It doesn't make sense. And so now that standard's been aligned. But ultimately my view all along was, well, if you actually look at, yes, the names of the standards are different, but when you actually look at the analysis, it's not really different. And when you factor in that the PTAB judges have insight into the science and technology, that's really what drives the more concise constructions in my view. And whereas when you're in the district court, there's all these nuanced positions, and you may have a judge that feels inclined to, uphold this government, issued instrument, and, maybe you can split the baby and thread the needle and all of that. And, when you're going back to the agency, you're getting an expertise there that you don't get in the district court. So when you get down to, well, what is BRI, what is Phillips, and you look in the MPEP and BRI is referencing Phillips, and you're looking at the same intrinsic record, it's really not that different. And so, the outcomes have not sort of diverged in any material respect since those standards have been aligned.
Yeah.
I disagree with Scott, if you want to hear why.
Yeah, sure. Go ahead, Jim.
Why I disagree with him this time. When I was in APJ, we had the BRI, and we leaned into it. It's like, whatever the words are, the application is, how far can you stretch this language and still not violate something explicit in the specification? To me, that's a lot different than trying to figure out the plain and ordinary meaning under Phillips. And we stretched it under BRI. We did.
but that's stretching the guardrail as reasonableness. So you can only stretch it so far, right? I mean, are the Phillips constructions unreasonable? I think at the end of the day, yes, it says broadest, but it's broadest reasonable. And so, I just haven't seen that many cases where the distinction has made a difference in the outcome.
Andre, your thoughts on the big issue, or you could, because you were there when the Patent Office codified that.
It was a brilliant change.
Of course it was. But it was also,
if you think that the standards were actually different and had a disparate impact, as Jim thinks, and I also agree with that point of view, by the way, at least on the edge cases, then you should align the standards, because after all, we have one country and there's one patent. It should have a certain meaning no matter which tribunal looks at it, right? It's a piece of property, it should have a particular meaning. On the other hand, if Scott is right and it makes no difference, then why have two different standards, right? Why have two different standards that actually, according to some people, it's the same in practice? Because what that did in the past is it created opportunities for gamesmanship over in court, and confusion as to the standards. But in the end, that change was made in the summer, approximately, I think, of 2018. It's been, 5 years already, or more, almost 6. And it's working fine, and nobody's really complaining about that, I don't think. And it was codified with notice and comment rulemaking. It's also part now of the proposed statute, the Prevail Act, which we can talk in a bit about. Mm-hmm. In terms of big changes, again, I don't think there have been any major changes at the PTAB. I will say that obviously the major change in practice is the director review, which is newish since the Arthrex decision at the Supreme Court in the summer of 2021. Director Vidal, over the past year and a bit, has put in her approach to these director reviews. And it is a meaningful change in practice. The fact that there is this additional layer of review with decisions issued by a single individual and not a panel of 3. What impact that's going to have, we'll see more in the coming years. The one concern I have several concerns with director reviews in general. The biggest is that, look, in the end, the director is a politically appointed person that comes and goes at different times, and you're going to have different people, not just as human beings, but different backgrounds, different experiences, different levels of competence in these very complex areas. And I think the public has a certain level of discomfort with having, again, political appointees that come and go, resolving private disputes between two private parties on an individual basis. So, I think there are some, but that's the law, right? The Supreme Court said that's the Constitution mandates that the ultimate final decisions from the agency have to be subject to review by the political appointee. And, if you go at the 30,000-foot level and look at the PTAB, in the grand scheme of things, this is one of the core problems one of the core discomforts that the public has had with the PTAB ab initio, which is that you're basically trying to put an adversarial proceeding between two private parties in an administrative agency that is, as the Constitution mandates, politically driven and or is subject to political oversight. There is a reason why the founders of our country have created a separate branch of government that's completely independent with lifetime appointed judges that are divorced from the comings and goings of different administrations over time. So trying to square this this discrepancy between having private disputes of real importance between private entities in an administrative proceeding on the one hand, versus the public's expectation that this should be done by dispassionate judges that have, the imprimatur of independence. That contrast has created all sorts of issues from the beginning of time of the PTAB. And now, to some extent, this new approach that the Supreme Court is requiring and the way the PTO is implementing it has the potential of creating even more discomfort, especially as we, over time, will move from administration to administration to administration. And that is something that I think needs to be worked out in the long run to try to alleviate these issues. And there are ways of doing it.
Okay. So there's a lot there, and I don't know what I think about the standards, but I do, and I know this will come up later on in a panel that we're going to devote specifically to this tomorrow. But I think one of the big issues that I see is still re-examination after IPR. Now, I'm pretty simple, and I understand the difference in the standards, and that's sort of where I wanted us to have a little conversation about that a little bit, because I don't know why we should, like, if we were going to get in a room and say you can't come out until you have agreement and we go all close the door, I'll tell you, I'm going to be very difficult to convince that there should be re-examination after IPR ever, because the PTAB is going to be the ones that hear the IPR. The PTAB are the ones that are going to ultimately hear the re-examination. And if they wanted to pass on one channel, why are they going to not pass on the other channel? And it seems like junk on a bet. You couldn't come up with a stranger way of doing this. And not to steal the thunder from that panel, I'm sure there'll be an awful lot of nitty gritty that we need to go into. And I also understand, I understand the actual, what was it, the Intel case. That was an odd one, right? Because Fintiv was we had Fintiv on steroids, and they were never really given an opportunity to challenge, perhaps. I think that we're not going to see that anymore. But what say you all? Do I have any volunteers to start that round robin? Jim?
Sure, I'll start that. There is a useful estoppel provision once there's a final written decision in an IPR that you can't request re-exam on issues that you brought or could have brought in the IPR. But the real problem, as I see it, is when there's a non-institution decision and on at least partly on the merits, and then they go down and file a copy of the petition as a re-examination request, which has a lower institution standard, and there's just no finality then for the patent owner.
Mm-hmm. So, Scott, I want to go to you and bring you into this too, because I know that you've dealt with this issue recently as well, and you'll be on the panel tomorrow when we talk about that. So, not to steal your thunder, but when we're looking at what's going on at the PTAB, circa 2024, I think that's a big issue.
It's something that sort of, I guess, became a bit more commonplace with Fintiv. Re-examination had become somewhat of a forgotten mechanism. And so there was this thought of, I put together this petition. I had what I thought were great positions, and the agency came back to me and said, well, we're not even going to look at the tech or the merits of your positions. We're just going to say, as a matter of discretion, we just don't think that we should be looking at it. And so if you're a petitioner, you sort of look at your petition and by and large it was an obviousness case, and you're thinking, well, it's an obviousness case, right? I'm probably not going to get very far in the district court. What's the downside of filing a reexamination? And I think in that context, you can talk about the equities on each side, and should if the patent office is saying on the one hand, we shouldn't be using our resources because there's this accelerated litigation somewhere that's also looking at the same things, and maybe the entire patent office should be working the same way. That's one argument. But then there's the other aspect, which you mentioned in that Intel case, where, well, if these are viable, positions, and there's some aspect of the patent office that will look at them, well, as a petitioner, why wouldn't I at least take a shot, because I'm probably not getting much mileage out of this in the district court. So that's sort of been the mindset from the petitioner side, and that's kind of how it started, as driven by more of the discretionary, because there was such a volume of those. But over time, and I'm representing a number of patent owners in this situation, you see cases where the merits are considered and they missed, right? They came up with what they thought were their best prior art. They didn't get instituted, right? Some aspect of the claim wasn't there, the prior art was deficient. And then they go out and do another search, get some different art, and then they go back in the re-exam. And that seems, just from a big picture perspective, to be an end around the IPR system. This was there as an alternative to litigation, whether you agree or not that it actually serves that purpose. But for someone to miss on an IPR, if they tried to file a second IPR, the PTAB would tell them, no, you had your shot. And to be able to go in another door at the patent office, that doesn't seem fair.
No, it doesn't. And the question that I also have about that is, I think and we're probably not there quite yet, but as AI gets better and better and better, what is a search that is a reasonable search, or what could have been done or should have been done or could have been found or should have been found, is going to change rather dramatically. And I don't know how that affects anything here, but I hear a lot of people talking about that search aspect.
Well, it's also a bit of a gap, I think, in the IPR statutes themselves. And that estoppel you're talking about kicks in at final written decision, right? You miss at institution, there is no real estoppel. So that, right, the patent office doesn't have to do that analysis on a re-examination. And there's some cases that have happened where the petitioner literally kind of just took the same art and tried it again, and that was the Vivint case up at the Federal Circuit. And so at least the Federal Circuit has said, well, look, you can't, right, just use the same prior art, but that's a corner case. So if you just go out and get some new prior art, you can come in another door where you couldn't do that in an IPR because of, it would be viewed as serial petitioning. And so if one aspect of the agency is saying, no, you can't do that, and another one is saying, oh, no, it's fine, that's an issue.
Yeah.
Challengers can still use the same prior art in a re-exam after non-institution. Vivint, said it was very limited to the facts of where it was already determined to be an abuse of second filing, and then you have a third filing. And the PTO has publicly said they have never seen another case that Vivint applies to. And so very corner case.
And we'll save some of this for the re-exam panel, but it's also interesting in that determination is made by an examiner, which, not to disparage examiners, they're very smart and intelligent people, but, they have to apply these policies and legal precedent from the PTAB, and I just don't know that they're the people that are best suited for that. That should be going to the Office of Patent Legal Administration, and currently it goes to an examiner, so that's another issue with it.
So, Andre, do you have any thoughts on that particular issue and re-exam afterwards, or what feel like for patent owners the never-ending challenge?
Yeah. So one of the problems, with the current state of the patent system, is that patents and patent owners are subject to death by 1,000 cuts. There seems to be a never-ending stream of new challenges that can be brought against the patent. So, and we combated a bunch of it when I was there at the PTO, but it's a constant, never-ending opportunity that is presented by various statutes and overlapping statutes. So you have the issue of serial petitions against the same patent by the same or related people. right? Serial IPRs. We dealt with that in General Plastic. You had the issue of parallel IPRs, where you file a gazillion at the same time against the same patent. So we dealt with that, you know, in the trial practice guide to some extent. Then you have the issue of multiple attacks as between the PTO, between the PTAB, and the district courts. And that was the concept behind FinTIV and the Sotera Declaration in combination, to have just one of them, pick one and go with that and not the other. Now you have PTO within PTO, which is the PTAB and re-exam, and there's no limit on the number of re-exams you can bring even. And that's yet another, I want to say loophole, but it's not really a loophole. A lot of these things are, frankly, by design at some point in time. To me, you know, in a fairly functioning, balanced patent system, obviously the public or the accused infringer should be allowed to challenge the validity of the patent. But do it once, do it right, and don't do it again. Pick a venue, pick a proceeding, and do it, and then let justice take its course from there. If a mistake is made, that's what the appellate process is for, right? If either the PTAB made a mistake, or the district court made a mistake, or the re-exam unit made the mistake, there's an appeal process from there. Let that take its course and have that correction, not these other parallel, serial, multiple challenges in different venues. It's exhausting for the patent owner, and it really destabilizes the system. So I really hope in time there is some new approach that can close down all these loopholes,
Yeah.
and ensure a single challenge.
So one of the things that I've written about in the past, and it hasn't gotten any oxygen, and I don't understand why that is, maybe because it's a good idea and it would streamline things, and it seems like what we've gone down this path is to bifurcate, except for where we trifurcate. And I think what you need to do is like what we do with real estate, with tax sales, with bankruptcy. If there's going to be a challenge to a patent, come one, come all, come now, you know, and put a notice out. Give 120 days for everybody who's interested to join, and let's do it here, do it now while you're interested. If you're not interested now, we have some kind of corollary on the trademark side. You know, if after you go incontestable, then the number of things that you can challenge goes down to practically nothing. Why can't we do something like that on the patent side, whereas the trademark asset could last forever, really, and the patent lasts for at best 20 years. And who's fooling who? It's not 20 years. It's 17 years, and it's usually not even 17 years. And for the really valuable ones, like in the pharmaceutical area, they get like maybe 10 or 12 years worth of protection, right? So we're talking about an asset that is a wasting asset to begin with. Why can't we do something like that happens in every bankruptcy court across the country every day?
So the answer, just if I may jump in, Gene,
Sure.
The answer is you definitely can do that, and many other countries have that process. It's called an opposition process, and you don't just come one, come all at any random period in time. You come at the very end of the patent prosecution process at the PTO. The PTO issues its decision whether to issue a patent or not. Then there is a window that opens up, call it 9 months, and during that 9-month window, come one, come all, you can challenge the patent, and then you're done. It's basically a short extension of the patent prosecution process, of the examination process. That was, in fact, considered during the AIA. That was the general concept behind the PGR approach. The mistake is the open, never-ending second window that was negotiated. This issue was squarely on the table 10, 12 years ago, and it was negotiated and it was rejected, and the system that we have now is what it is. Other countries have an opposition process, a first window only, and we could do it theoretically, but the political winds, I think, I don't quite see it.
Yeah. So Jim, you're not that you only do petitioners, you do patent owners. You do almost all patent owners, right?
Right now,
So,
it's
so
all
what,
patent owner, yeah.
what would your patent owner clients, do you think, say to something like that? Would they be for it? Would they be against it? Because when we were going through the AIA, the thought was we don't want to have an opposition proceeding because then nobody will ever wind up getting their patents. They'll always be in opposition.
Well, like Andre said, that's the PGR setup. And of course, we have the third window also, and the fourth window, and the fifth window, and the sixth window being a few re-exams and the district court. So there's a lot of windows, as you said, 1,000 cuts. But our patent owner clients would like some, have their rights settled at some point.
Yeah, it's what it seems to me, Scott. What would I mean, and not to say that you only do petitioner, but you do. What is it? 2 to 1? Is it 3 to 1?
It's probably 2 to 1.
2 to 1. So, what would your petitioner clients, do you think, say to that? Would they be for it? Would they be against it?
I think they'd be against it, and they would probably explain that the European system is different, right, than the U.S. for a number of reasons, but. The reason it works in Europe is because competitors are looking at competitor portfolios, and as the patents are coming out, well, that might be a problem. We'll challenge that one. And if you look at what's driving the litigation in the U.S., it's not right. It's not Apple versus Microsoft suing each other. It's some small company that got some funding or went out of business and sold their patents. And it's not even so much that they're small companies. It's a lot of times it's, well, I read the patent, I read the claims, there's nothing to do with my business, why would I challenge it? And then you get a lawsuit with, very creative claim constructions, and you read the patent and you say, well, you didn't patent that, right? That's not what you claimed. And so it would be hard, I think, for companies to, police patents that way and in a systematic fashion when you rarely can see what's coming down the pike because by and large, what drives the volume of litigation in this country is not competitor suits. And there's also a vastly different damage system here, right, where you don't have that kind of, we'll just call it a business opportunity in Europe to sort of use patents and argue around the edges of some of the claim constructions and things. So that's the problem. And I think secondarily, there is at least an aspect of the AIA statutes that tried to do this, and that's this joinder issue that sort of reared its head in that Intel dispute, which is, well, if you are outside of your 1-year window and someone does challenge a patent, why don't you come in, let's get everybody that's interested in this patent to have their say. And that's sort of created issues. So there was at least, I think, and there's no legislative history that I'm aware of on the joinder provision, but that's the way I've always interpreted it as well. Let's, while the PTAB is looking at this patent, even if you are boxed out on your 1-year window, why don't we let you come in and take a look at it? And that's not worked out well, I think, for patent owners.
Mm-hmm. So Andre, what's the fix here? If we want to, because we all talked about this during our call, is to try and maybe get past just the talking about and come up with ideas that would make things better. What's the fix for this or for whatever the issue that you think would do the most good to make the PTAB better?
Well, there are many things that need to be fixed. The first and foremost issue that needs to be fixed is the multiple attacks on a patent. That's the most important thing. So I don't think anybody's arguing that if they have one challenge, it would be unfair. I don't think folks are arguing that it would be, quote, unfair to limit them to a single challenge. Sure, if you're a petitioner that gets sued a lot, you want to have as many bites at the apple as you can. But that doesn't mean that that's the fair thing to do. So we can statutorily close the loopholes so that we have a single bite at the apple, whether it's in court, at the PTAB, or the re-exam unit. Pick one, that's where the challenge is going to be, and that's it. So that's one approach. One thing that needs to be addressed. There's several other things. Standing is another issue that some folks talk about. There is a reason why under common law you require somebody to come seek redress to have an interest in the proceeding, because if they don't have an actual interest in the proceeding, they can cause a lot of mischief. There is no current standing rule at the PTAB. A third issue is the burden of proof. We did equalize the claim construction burden standard by rulemaking. But the burden of proof, that requires a statutory change. It is clear and convincing in the district court, but preponderance of the evidence at the PTAB, again, it's a private dispute between two private parties on the same patent in two different venues. Why are you not requiring the same burden of proof? So I think that loophole, in my view, needs to be closed as well. There's a bunch of other things, but all these things are doable theoretically as long as there is a public will to make that change.
Mm-hmm. So Jim, what changes would you make, either picking up on what Andre said or on your own? What do you think would make the system better?
Well, certainly if we had the European system, where you have 9 months to challenge and then you're out. Patent owners would definitely like that. Most of the patents we do, they don't become valuable for years and years anyway. So that would be a pretty sweet deal. Picking up on Andre's point about the political winds changing things, there's two things there. One is that I don't know if you all heard the Supreme Court arguments the last couple of weeks on overruling Chevron, but interesting discussion there about how, because they're deferring to agencies and agencies change with each administration, they've had cases where the meaning of a statute has flip-flopped with different administrations when the new administration comes in and interprets it differently than the previous one. And that's really strange. We'll be watching out to see what the Supreme Court does about Chevron. That seemed to be a legitimate objection to Chevron. And then Director Iancu, started the precedential opinion panel at the PTAB. That was a really good mechanism to provide some certainty, it seemed, but then perhaps, under cover of Arthrex, or because of Arthrex, I should say, the current director got rid of the Presidential Opinion Panel program, and that leaves, in my mind, a question of whether all of that hard work that the POP did in making certain cases precedential or not is still meaningful. I don't think that anyone knows the answer to that. I think that's why FinTIV hasn't been explicitly overruled, because nobody knows how to do that, or if they can, but they sure know how to make exceptions that swallow the rule. And so I think that's an odd thing that needs to be resolved.
So let me throw this out at you. I think that they haven't overruled FinTIV because they really like it, and they could see it being useful at some point in the future. And if you get rid of it, then how do you say, oh, well, we should never have done that, let's get rid of it? How do you bring it back? Because I've told people that I think the answer is not to have the director have less authority of what goes on. It's to have the director have more authority. I mean, it's clearly keeping within what the Supreme Court wanted. And as a director, you have to, I would think, and I'd like to get your comment on this, you have to manage the agency resources. You can't be just keep looking at the same thing over and over and over again.
Yeah. So first of all, my views on whether the director should have more or less authority depends on who the director is. And that changes from time to time. But kidding aside, look, I think FinTIV is very good policy, right? Again, it goes to the point of pick a venue and stick to that venue. You're entitled to have, remember, it's not just FinTIV, it's FinTIV together with Sotera, okay? So what that says is if you tell us you want the PTAB, but you only want the PTAB and you don't get a second bite in district court, you can have the PTAB. If you would rather have the district court, God bless, go and do it in the district court, but don't come back here. So it's good policy. Now, so maybe that's why they didn't overrule it, because the PTO and the director and the staff understand that it's a good idea to have. Having said that, if they want to overrule FinTIV, or if they want to overrule any of the other precedential decisions, they can easily do it. You just withdraw, and they've done that in the past. You withdraw, you de-designate a particular decision. That's what you have to do. It's not a big deal, theoretically, from a practical point of view. It's a question whether you think that's a good approach and you can sell it. You can sell it to the public. I will say that a lot of these things, the public needs to get together. It's been 10 years, 12 years now of the AIA. There have been so many ups and downs. I think it is time to have a relook. Have the public come together and have a conversation. Let's put it out all on the table. What will it take? What are the changes you would make, big and small, to have the PTAB be a fair tribunal that people accept as a fair place to be instead of district court? One answer could be that the public agrees it shouldn't be there at all, as some people say. But if the public generally thinks it should be there, let's come up with the fixes to make it right. I happen to think that the currently pending Prevail Act does a lot of that. It goes a long way to fix a lot of these issues. Not every issue, but a lot of these issues. Some people agree, some people disagree. Let's have that public debate, make some decisions, implement them, and try to make this a more fair, at least a more accepted tribunal by the public.
Yeah. So Scott, I don't think I've asked you what your way of making things better would be. So let's start there with you. What say you?
Well, as I mentioned with the hearing, I mean, there are just layups that you're giving to your opponents if you're the patent office in terms of what you're doing, and taking those away just seems like a no-brainer, whether it's coming up with a rule that, look, if a patent owner wants a hearing, we're going to have a hearing. That's easy enough to do. Same thing with the re-examinations. When you're trying to explain this to a client, in the C-suite somewhere as well, you've got this system. You make a challenge to a patent, and they determine that it's not a good use of their resources for this litigation, but you can then go in another door and do it. You can't really defend that on any level. If you're up on the Hill or whatever, I mean, these are just, I wouldn't want to be in that seat if someone asked me that question of, well, how is it that you apply this policy discretion in this door, but it's different in that door? And so there's a number of things like that I think, show that you have an interest in adjusting the system for fairness, for patent owners. Doesn't mean, you have to change things radically, but there are layups that, you can eliminate. I will say on the question of clear and convincing evidence, I know that's a big part of the Prevail Act. I don't know that that's going to make the big difference. I'm not saying it would make a difference, unlike BRI and Phillips. I think it would make a difference. But, when I'm on the petitioner side and I see patent owners, making arguments in front of different judges that understand the science, understand the technology, and they're basically arguing obviousness issues, right? I've said before, Gene, the PTAB's an obviousness court. So a lot of times, especially when litigators come into the PTAB, they, not surprisingly, use what works for them in district court, which is attacking the references individually, or saying, well, if you bodily incorporated this circuit from the secondary reference and put it in the primary reference, it wouldn't work. Clear and convincing preponderance of the evidence is not going to allow you to win on those arguments. And that is 60% of the cases that I see. And then, second, the problem, I think, with arguing for clear and convincing evidence, and I pointed out this before, is you're asking the patent office a different question. Ultimately, yes, they can kill the claims. District court can kill the claims. But the district court is looking at it from an outsider, right? I've got this government-issued document. We don't have the government's expertise here. We don't know why they issued it. If we are going to second-guess them and substitute our own thinking here, it needs to be clear and convincing because we are presuming that patent is valid. Now, when you go back to essentially the agency that made this decision in the first instance, you're asking them a different question. You're saying, knowing what you know now with this information in this petition, using the standards of patentability, the reason you issued this patent, would you have issued this patent applying those standards? And that makes sense. On the other hand, if you go back and say, well, let's change the standards to clear and convincing, now you're not asking them to relook at their work. You're asking them to assess invalidity as if they were an outsider. And I just don't think logically that makes a lot of sense.
Can I respond quickly
Sure,
to that?
absolutely.
That Scott's right. That is the argument that's being made. But I just think it's exactly upside down. If anybody should give deference to the PTO's work in the first instance, should be the PTO. John Whalen went on Capitol Hill and he testified. He says the only tribunal in this country that does not give deference to PTO examiners is the PTO. The fact is that there needs to be, the public and the patent owners need to have some semblance of quiet title at some point. And once the patent issued, it seems to me that everybody should presume it to be valid and go from that perspective. One final point on this. These are technical and technocratic arguments. The bottom line is this. The public needs and the patent owners need to feel that they're being treated fairly. If it's one patent in the United States, it should have one meaning and it should be analyzed vis-a-vis the prior art under one standard. It shouldn't be, the patent shouldn't be valid or invalid based on the happenstance, at least at the objective level, based on the happenstance of whether it is at the PTO, at the ITC, or in Article 3 courts. And that would give a lot more confidence, both practically and theoretically, to the public, I think, in this process.
That's very well said. And the clear and convincing standard is arguably at odds with the presumption of validity. How can both of those exist at the same time? I don't quite get that. Basically, what we have now is no presumption of validity. That's just what we have in our country now, despite what it might say in the statutes.
I would agree with that. Before I give my thoughts here, how about I ask the audience? Does anybody have any comments, questions, anything from the audience? Before, okay, so I don't see the audience.
I think you should call on them, Gene. Like
I should call on them, right?
Socratic
Like
method.
I'm a teacher. So I mean I go back and forth with this, but I fundamentally, I guess, don't think that these words that we use to distinguish these different tests, to distinguish the different procedures, make any difference whatsoever. And I think that's, to pick up on what Jim said, I think it is just this, do you like patents? Do you not like patents? It's the way you look at the world colors the decision far more than is it reasonably likely that at least one claim, or is there a substantial new question of patentability, or is, whatever the test may be, and then clear and convincing versus preponderance. I mean, I'm in favor of having this be one system across the board with one set of laws and one set of rules, because I think that eliminates the gaming that goes on. But will it change anything? The only way in my mind, and I'd like to get maybe all three of you to comment on this, that it would change anything by having a unitary set of language or rules and tests that apply across the board to all of this stuff, is to send a message that patents matter to the people who are the decision makers. And if you're going to undo what an examiner did, you have to be pretty sure. Like, I'll say this, I thought that when I was looking at Judge Michel here, I said one time, and I don't know whether you remember this, it's like, I'm not adverse to disagreeing with Judge Michel, but if I'm going to disagree with Judge Michel, I take a deep breath and think twice, because Judge Michel's almost always right. I would like to see the examiners take the position, or not the examiners, the PTAB and district court judges and all the decision makers. If you're going to go against what an examiner has decided, take a deep breath and think about it twice. Because they're the ones that live with this application for 15 to 40 hours, depending upon the art unit and how much time they're given. Andre, you want to lead off?
I couldn't agree more. You have to keep this concept together with the concept of a single tribunal. Don't have multiple proceedings. So eliminate all the proceedings but for one, for a particular patent, and then eliminate or coalesce all the standards to be the same. So you eliminate the forum shopping and all the other gamesmanship that takes place. And it would make a difference. It would really simplify the system, it would reduce the costs, and those two things together would increase the confidence patent owners and the public have in the patent grant. And you can make plans around it, whether to invest in it, whether to invest around it, all sorts of things when you have more certainty in what the document means.
So Jim, your thoughts on what I said, or maybe picking up on what Andre?
Yeah, so Gene, you mentioned examiners live with the application for 15 to 40 hours, but don't forget that they are super specialized in that area. So they might live within that very specific niche for 5, 10, 15, 20 years and really have a body of expertise about that very specific area that nobody on the PTAB is ever going to have, because there's only 3 art units, if you will, or 4 at the PTAB. One of them is electrical and computer. That's a very broad area. So, but it's hard to defer to people at a lower GS level. I get that. And picking up on what Andre said about a unitary system making it feel fairer for patent owners, I think it's really important, because patent owners don't feel like they're getting a fair deal. And I think I'm hearing more and more that people want to do, keep things secret. Why reveal things in a patent that's just going to be shot down? Yeah.
So Scott, your thoughts before I say anything more?
Yeah, well, I'm obviously in the minority, but and I think it's just a matter of perspective. As someone that's gotten thousands of patents, I prosecuted for a long time.
How many of those are valid, Scott?
30%, maybe.
All of them, right?
No, I mean, I'm honest. Most of them were not, and that's just the way that it is, right? I mean, it's there are some very skilled examiners that have been there for decades and work in these niche technologies, but the vast majority of the litigation is not in the niche technologies, right? It's in interfaces and some of these more basic technologies, and you have a lot of mistakes being made, and there needs to be a way to address those mistakes before it gets to the point of taxing American industry hundreds of millions of dollars. That's the balance. We always talk in terms of extremes. And yes, there are great patents out there. There are great inventors. There's also, and I tend to see this more often than not, some very bad people that are exploiting the system. And we have to have some kind of balance to get at those abuses. We just can't have it unbalanced one way or the other. We've got to meet in the middle, and that's been a challenge across the board in patent law and 101 and other areas. And I just think this country, unfortunately, is on the ends of the spectrums on just about every issue these days.
Yeah.
But, one thing that's not answered by that very good point, which is there's abuses in the system, you have to deal with them. What's wrong with the court system? The founders created a divided government with independent courts that for hundreds of years have given the public great confidence in outcomes overall, on balance. And what's wrong with allowing the courts to deal with those abuses? And one more point that I think is really important. I'm a great believer in the jury system. What's wrong with letting juries who are fresh to every case, dispassionate, disinterested, not jaded, what's wrong with letting them discharge their constitutional mandate to adjudicate these issues? And if they make a mistake, and they do because they're human beings, from time to time, you have the judge to correct it. And if the judge makes a mistake, as she does or he does from time to time, you have the Court of Appeals to make that correction. That system has worked for a very long time, and and to the extent we can push things towards that system, the public has great confidence in it. It's one of the last vestiges of government that the public still trusts, and I think we would be well served in the patent community to allow the Article 3 courts to discharge their duty as they have for a very long time.
So the thing that we were talking about, Scott, before we started here today is on a separate project that I've been working on. I've had occasion, and I do this every so often, as I go and I just kind of peruse the Gazette to see what gets issued. There are some shockingly thin, to be generous, patents that are granted. But the thing that frustrates me...
Not between 2018 and 2021.
With that period of time excluded, of course.
Exactly.
But what shocks me is that we have this duality at the Patent Office. And I always say, if you're going to try and shoot something off, Kennedy Space Center, shoot it towards Pluto, it's going to be on this mission to orbit Pluto, deep space kind of thing. The level of newness and non-obviousness that has to go into something like that is shocking. And it probably should be shocking, right? But if what you're going to do is sell this on QVC, or you're going to put it on the shelves at Home Depot or Lowe's or Target, what needs to be different is such a sliver. Sometimes it feels like it is almost the color that will get you a patent in some of these areas. And it's maybe not exactly that bad, but it is pretty damn close. And I look at these things and I think to myself, my God, I could be an inventor. Anybody could be an inventor if that's the standard. And I think to myself that what we're fighting here with the PTAB is this perception that the Patent Office is giving too many patents across the board on weak, thin stuff. But it only gets played out against the commercially lucrative, valuable stuff that does have an order of magnitude, maybe not enough of a magnitude to please the particular decision maker. But this is not the ordinary 80% plus that goes on at the Patent Office that we're talking about. We're talking about vetted patents that are making people money that get challenged. Now, I don't know where to go with that other than that's maybe my final thought on where we're at the PTAB right now. So what I would like to maybe ask each of you, if you want to respond to me, that's perfectly fine. But if you want to also give your own final thought here today to wrap up, what is that final thought you'd like people to walk away from this conversation with? Jim, why don't we start with you?
So first of all, I think color can be a distinguishing patentable feature. In fact, last week there was in the news a story about a patent that was granted to a 7-year-old, I think it was, for a color-changing Lego brick. And it wasn't just the concept, it was also how to accomplish it. It was pretty cool. You paint the bricks a certain color, say white, but you use a paint that when wet goes clear and reveals a second color underneath. I thought that was pretty cool. So I'd be okay with that kind of patent. But on a more serious note, perhaps, to pick up on what Andre said about juries, they're really good at applying the presumption of validity and, to Scott's point, ferreting out really bad people, if I've quoted you correctly. Mm-hmm. I've testified in, 80 cases or so, and so I've seen how the courts play out, and I have a lot of respect for them. So I'd agree with what Andre said about that.
So Scott, let's go to you, and we'll give Director Janka the final word here. What is your wrap-up thoughts?
I mean, to me, it all comes back to the same thing: is we need to be able to weed out mistakes. The present system may not be perfect, but we can bring it into balance. We've had numerous verdicts over the past couple of years in the billions of dollars, and these are successful American companies that employ hundreds, if not thousands, of engineers and are important in some cases to our security and defense, and we need to be really sure in those cases that, this is fair, right? This is an idea that was stolen. This isn't just some patent claim that, is broader than it should be. And, the examiner that looked into it only had 40 hours, didn't have time to do the greatest of job. Maybe they were 24 years old at the time it was their first job. That happens. And we need to be able to get at that. Certainly the courts can look at these things, but we also know that there are courts in this country, not naming any, that are doing Markman hearings in almost a drive-through fashion, and there's various industries that have popped up around the country that are problematic, and I think the PTAB brings a lot of balance and a lot of value to. You can disparage them as big tech, but they're successful American companies that need a way to solve this problem, and I think the PTAB does that. But that's not to say it's perfect, and it's not to say that we can't, like I say, take away some of those layups of unfairness that shouldn't be there.
Right, agreed. And Director Iancu, your final thoughts here today.
Yeah, look, as I've said, we've had about 12 years of experience with the PTAB now. We know all the various issues. We know the good and the bad. And generally speaking, there is some common understanding as to what it would take to fix the various issues. But there is not yet broad-based agreement. I really think we have a very good vehicle in the Prevail Act that's currently pending both in the Senate and in the House. Let's get the folks who care about the system to come to the table. If you like the bill, if you don't like the bill, if you have ways of improving it or things to add, things to subtract, let's have that conversation now. It's time to fix it and get it right. It's absolutely doable. It's imminently doable. And I really would hope that whoever has any concerns come into the public square, different venues, and have that conversation. My final thought is this, on top of all that. We have, the patent system is incredibly important to the American economy and competitiveness as we get into the next industrial revolution, the technologies of the futures, like AI, biotech, and all that stuff. Incredibly important. We can't abandon it. We just cannot abandon it. Neither can we just sit around and complain about it. We have to do something about it and just get it right.
Okay, great. Well, thank you very much. Thank you, everybody, for being here for this